Welcome back and welcome to Business and Immigration Law Updates. This is proudly presented here by an internationally renowned attorney by the name of Mr. Khurana. This attorney is the chief and the head of the Khurana law firm, which is located in the heart of Gaithersburg, Maryland. And this said attorney Kenneth Haber is the moderator. This week, Attorney Haber questions Attorney Khurana about the H-4 visa holders and their eligibility for work authorization. Now, that's very interesting. Come close. Let's take a look.
Welcome. My name's Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney in the Office of Inspector General, United States Department of Health and Human Services. That's the Medicare cops. I'm here today to introduce you to Ramesh Khurana, who is a presenter, who is a internationally well-known immigration attorney who represents people from across the world, literally, because of the fact it is an immigration base that he has his work in, and he represents them so well. He's located in Gaithersburg, Maryland, and this is the Capital Forum. Welcome. Welcome, Ramesh.
Thank you, Ken. I appreciate.
My pleasure. Are you ready to take some grilling from the people who would interrogate bad people? And you're not a bad person, so it's going to be rough on you.
You are a good person. I know that. I know that.
Well, we're ready to grill you now.
Sure.
On immigration.
Yeah.
Because that's when
so long as it is immigration field, you ask me any tough questions.
Well, we're going to give them tough to you.
Sure.
Yeah. Is it true that the USCIS allows H-4 visa holders to work in the United States?
The good news is yes.
What's the bad news?
Bad news is earlier they were not allowing. And other thing is when you are talking about H-4 visa holders, not that everybody is allowed, that's the bad news.
That's the bad news.
These are only the spouses.
Oh, yeah, spouses.
Only the spouses who are on H-4 visa holders.
So the kids can't?
No, the kids, because first of all, kids can be on H-4 visa if they are under the age of 21. So now let's say a person is now 18 and he is on H-4 visa, he cannot be allowed to work on H-4 visa. Because this special concession has been extended only to H-4 spouses under certain circumstances.
The spouses.
Yeah.
So that's the bad news.
That's the bad news.
That's the bad news.
But believe me, you know, good news, as I said, just a few years back, H-4 spouses were not allowed to work, and then they had to work harder to come on H-1B visa by themselves to start working. And they sometimes these spouses, they are equally very talented, well accomplished and well educated people, and they were just sitting doing nothing.
Sort of like in the 1950s sitcoms with the wife
Right.
sitting at home and the husband's going out to work being a doctor.
Maybe husband or wife, either way.
Yeah.
You know,
Well, in the 50s,
wife,
in the 50s it was the wife always staying home.
I know. So basically, let's say that
Only
now,
took us 50 years to catch up, huh?
right. If wife has come on H-1B visa, then the husband is on H-4, and then that person was sitting idle. He was unable to do anything, even though he could have been gainfully employed, and he would have increased to the productivity of this country. And he is a talented person too.
Yes, I'm sure.
Yeah.
If he's married to
Yeah.
a talented person.
Yeah.
What's the process? How do you become eligible as a H-4 visa holder to get that exception to work?
I knew you would ask me this question.
Ah, well, because we think along the same sneaky lines.
Right. So Ken, there are only limited circumstances when the H-4 spouse can be allowed to work on H-4 visa. Now, the most important condition is, first of all, of course, the principal is on H-1B visa, and the employer started the green card process for him. And the green card process, as we discussed several times on this TV shows, that starts with the labor certification process. So once the labor certification process goes through, the US Department of Labor, and we say that it has been certified, then you move on to the next stage and you have to deal with USCIS. And the employer has to file the immigrant petition, which is called I-140. And once the I-140 or immigrant petition is approved, at that point of time only that eligibility criteria is met with.
For the spouse.
For the spouse.
So what they want to do is see that this person is trying to create some roots.
Yes. So once the I-140 is approved, at that point of time you say that yes, my spouse is eligible to work on H-4 work authorization. Only then the application can be filed. But I would pass a word of caution to the H-4 visa holders applicants who have filed or would file their EAD application or work authorization applications based on this criteria. They should not start working unless and until the EAD card has actually arrived or so called work authorization is approved and they have got the card showing the approval of the work authorization. Otherwise, they should not be working on H-4 authorization.
Because they can be considered out of status?
Because that's called unauthorized working, which is a very serious irregularity, and this shows up sometime at the time of adjustment of status. So it becomes a big issue. So never commit this kind of mistake to work unauthorizedly unless you are authorized to work.
That makes perfect sense, you know.
Yeah.
And once they're authorized to work, that's when they'll be able to
start the work.
Establish it by they'll have the card.
That's very true. Yeah, I'm pretty sure employers are not going to allow these kinds of people to work unless they have the physical card in their custody, because they have to complete the employment eligibility form, which is called Form I-9, and they have to talk about the evidence which allows that person to work in the United States. So no employer who knows about these laws would allow a person without the work authorization to start working anyways. Yeah.
I imagine this would reduce some, once they get the card permitting them to work, the H-4 spouse, that this should reduce some stress in the family, would it not?
You know, you are 100% right, as we talked about this part little bit earlier, because the H-4 spouse is a talented person. He or she has all the educational requirements which are required to get any kind of good professional job, and that person maybe has a good work experience, and that person is sitting idle at home. If this person is authorized to work based on H-4 based work authorization, we are going to utilize that person's talent. So that family is really going to be happy, because otherwise there was only one source of income, which was the husband or wife, and now two people will work and bring home money for the betterment of their children.
What would happen if the H-1B visa holder lost the position? Would that automatically terminate the H-4 jobs certificate, or is there some time?
You said it. Because H-4 status is contingent upon the status of the principal beneficiary of H-1B, and if the principal H-1B beneficiary loses his job, so that person goes out of status overnight technically.
What if they're sick? They haven't lost their job, the employer says, this is a good worker, I'm going to wait till they're well. They're not working the person, but they're not firing the person. Can the H-4 person continue to work?
Sure, because if the principal beneficiary of H-1B is sick and the job is not terminated, even though that person may not be getting paid for the period of his sickness, 2 or 3 weeks, doesn't matter, because status is not lost. But if he is terminated for whatever reason, then this question becomes very important, Ken, because if that person is losing the status, the H-4 dependent spouse is also going to lose the status H-4, because EAD is authorized based on H-4 status, so underlying status is gone.
So they both then have to figure out some way of correcting their status or getting out of the country.
Yes. You know, one thing could be maybe, you know, they are eligible to apply for O visa, you know, depending upon their qualification. So they need to talk to an experienced and knowledgeable immigration lawyer who can evaluate the case and probably start something which can bring them back to status. Or I would always advise that these kinds of people, they are always very vulnerable, especially who are working for the IT consulting companies. They lose their projects, and once they lose their projects, they go out of status. So they should really have a consultation with the experienced immigration lawyer to know that what are their options in this kind of situation. Because once you lose the project, you go out of status, lose your status overnight technically, and then you are left with the option of finding a new job, either going out of the country and being readmitted on H-1B once the petition is approved by another employer, or basically you are asking for USCIS forgiveness if there is a gap of 20 days or 30 days. Of course, if you have saved money, then if your intent is to go around and see some places of interest in the United States, you can say that I want to switch over to B1, B2 visa. Then you can apply for B1, B2 visa and you can enjoy sightseeing. In the meantime, if you find another job, you can apply for H-1B. And then again the spouse who was on H-4 visa, she has to apply for H-4 visa along with the H-1B status, and once that status is approved, she has to apply for the work authorization again.
This gets, I'm sure, to be very complicated for people because the IT industry has a proclivity of a lot of changes in employment with different projects coming up, et cetera, et cetera. My son works in the IT industry and his company has a different model where they're much more stable in terms of employment, but he was saying how throughout the industry it's not like that.
That's very true.
You get your contract done and the company terminates you because they don't have something in the hopper for that minute, they don't want to keep a person on.
I agree with you. It happens mostly in case of IT consultants. But if a person is an accountant or person is a physician and they are on H-1Bs, the chances of going out of job are very rare.
Yes, yes.
Yeah.
Just that one industry is just...
Yes. Because these consultants who are hiring them, they are basically not hiring most of the times for developing software in-house. They are hiring them to basically place them on projects with third parties. So once the third party says, I don't need this person anymore, my project is complete. So this person basically is left without any job.
Most unfortunate.
And the difficult thing is the employer or the consulting company, that company knows that you cannot make this person sitting on bench. They have to pay that employee right away. Whether that person is producing any money or not, he may have become unproductive, but so long as he is your employee, you have got to pay him. Otherwise, this employee can file a simple complaint with the US Department of Labor. They will investigate the matter and they will get the back wages to this employee.
So you've got to bench them well, you've got to fire them, not bench them.
Fire them, and again there is a process. Once you have fired such employees, then you have to inform USCIS that you have terminated this employee. And other thing is, if you are terminating an employee, then you have to offer the expense of back home transportation to this person, saying that okay, since you are no longer working with my company, I offer you an air ticket basically if you want to go home to your go back to your home country. So if you don't take these steps, like you have issued the termination letter to the employee, second, you have informed USCIS that the services of this H-1B employee have been terminated, and third, you have offered the transportation expense for back home, the termination process is incomplete. And still, if the Department of Labor investigates you, they can order back wages.
If the contract was for a set period of time, do you have to give the ticket back home?
You know, if you are terminating the employee, because at any given point of time, if the person is on H-1B, so there would be some time left for the completion of H-1B validity period. Let's say the validity period of H-1B was 3 years and your contract was for 1 year, it goes away, but H-1B is still valid because you filed the H-1B petition for 3 years.
I see. So
Yeah.
it's not so much the job timing, it's the H-1B eligibility timing.
Because you told USCIS you want this approval for 3 years.
So if you put it for 1 year, then you're not in
Yes.
problem. But if it's
Yeah.
3 years, you're in problem.
Depending upon how much time is left on H-1B.
Well, thank you very much. It's been a pleasure having this insight shared with us, and I'm sure that our viewing audience
Thank you so much.
appreciates it
This is
also.
really a very interesting topic. I'm pretty sure our audience is going to be benefited by our discussion. Thank
Yes,
you.
I know I am. Thank you.
Thank you.